I want to talk to you today about a real pitfall that some defense counsel run into a trap at trial. It's very important. It's called the law of recent fabrication in sexual assault trials. And I'm going to try and explain it with an example. So let's say there's a sexual assault victim, and the sexual assault occurred 1 year ago, and she goes to the police 11 months after it. And she complains to police, of course, that she was sexually assaulted by your client, and the trial's taking place a year later. Now, as defense counsel, you have to be very careful during your cross-examination. So I'm up on my feet, I'm cross-examining this victim, I challenge her credibility and reliability. The last thing I want to necessarily do is say to her, look, this motive to lie just arose the day before you went to the police, and you're just making this up. It's a recent contrivance, or you're recently fabricating. In other words, I don't use those words. I say you're lying about this. You made it up the day before because you're mad at him for breaking up with you, or he owed you money, or some sort of motive like this. Whoa, whoa, whoa! What does that allow the Crown to do? It allows them to call a witness she told the day after the alleged sexual assault or rape that had happened. That's now a consistent story with hers. Now, normally the Crown's not allowed to call that witness, but you open the door. Your mistake of alleging a recent motive now allows the Crown to open the door to call a witness to counter that. And that kind of supports her credibility, and your client, you're kind of blown out of the water a bit on that theory. So it really backfires. I've seen this happen. And it happens a lot in cases where there's a delay in reporting, okay? So if you're gonna allege a motive to lie as a defense counsel, and that they made up the story, you better be sure that you're alleging that motive to lie before the person started talking to anyone. Let me put it that way. And I'll give you an example. So let's say a person is sexually assaulted on day 1, and they go to the police on day 6. When you're cross-examining at trial as a defense counsel, you want to suggest to her the motive to lie arose right away. And in other words, before she started talking to people, because if you allege it arose after she started talking to people, whoa, time out. Your client's probably lost the case, because the Crown's going to parade about 5 different witnesses. Oh, she told me A, B, C, D, which is all consistent with her story, which supports her credibility. So that's a law of recent fabrication. I've seen inexperienced defense counsel open the door unwittingly, and it's a complete disaster for their clients when that's done. You have to be very careful. You have to plan out your case, how you're going to present motives to lie and when. And please, if you're a defense counsel, or I remind myself every trial I do not open the door on recent fabrication, or your client's going to lose his case. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.